A major Supreme Court decision could significantly reshape pesticide litigation nationwide. In a 7-2 ruling, the court found that federal pesticide law can override state-level failure to warn claims, specifically involving Roundup and whether it should have carried cancer warnings. The decision marks a significant win for Monsanto and Bayer, even as tens of thousands of cases remain pending. Joining us now is an attorney who actually worked on some of the first cases against Monsanto, Pedram Esfandiari, a partner with Wisner Baum. Thank you so much for being here with us.
Thank you for having me.
So first, break down for our viewers, what did the Supreme Court actually decide in this case?
Sure. I think it will be easier to start with explaining what the decision does not mean. It does not mean that you can never sue pesticide manufacturers because their products caused you harm. For example, cancer and Monsanto in this case. You can still very much sue a pesticide manufacturer if exposure to their product causes you some harm, whether it's cancer or Parkinson's or some other kind of serious condition. What the ruling simply means in a nutshell is you cannot pursue claims against a pesticide manufacturer related to the label on the product. In other words, let's say a product causes cancer. You cannot sue the manufacturer and say, hey, you should have warned me on the label that there's a risk of cancer associated with this product. If that label, the court found, has previously been approved by the EPA without a cancer warning, you cannot sue a manufacturer because they failed to put a cancer warning on the label. That's all it means.
We know there were already billions paid out and thousands of cases pending. So what happens to those cases now?
Well, the cases are very much still proceeding. As I said, this is not by any means an end to this kind of litigation. Cases that are going forward in courts around the country, and some are part of the settlement program, they will continue. It just means that a portion of those cases, some of the claims in those cases, specifically the plaintiff's claims of failure to warn, which means Monsanto failed to warn them on the label of the product of a cancer risk, that part of the claim simply cannot proceed. But these plaintiffs have numerous claims against Monsanto. One of the other core claims being something called a design defect, which is Monsanto failed to design the product in a way that was safe. Those claims are still very much alive and can go forward. As I said, the ruling is very narrow and only applies to this issue of can you make a manufacturer be liable for not having warned of a serious health effect on the label of his product.
Now, some supporters of this ruling say the labels approved by the EPA should be the standard. What's your response to that argument, or some of the people who might be opposed to today's ruling?
I think that ignores the reality, which is the manufacturer ultimately has the most amount of knowledge about the safety of a product, has the knowledge to decide what should be on the label of a product, and leaving it up to regulators, we've seen in the past, has not worked. In part because in the past, unfortunately, manufacturers like Monsanto have withheld important information from regulators. That has materially affected those regulators' ability to design a label that makes sense and is correct in light of what we know about the science. For example, with Roundup, we have hundreds of studies demonstrating that exposure to this product can cause cancer. We have evidence that Monsanto withheld those studies in the past from the EPA, which directly resulted in the EPA approving a label for Roundup without a cancer warning. So I feel like this really shields manufacturers, and in a way it's the fox guarding the hen house, because manufacturers are no longer incentivized to make sure their labels and warnings represent the most updated version of the science that they internally are aware of and know about. We shouldn't just leave it up to the regulators when the manufacturers are best positioned to tell consumers what the risks are associated with their product.
I do want to ask you about a little bit of the flip side there. What was the Supreme Court's primary reasoning for ruling the way that they did?
I actually think it's interesting. Reading between the lines without getting into the complexities of the legal landscape, I ultimately think this was a pro-business decision. In other words, the Supreme Court was wary of putting too much of a stress and risk for manufacturers in bringing their products to market. They want to be able to shield manufacturers to some extent against claims, against litigation involving their products when they fail to warn of risks. In other words, is the Supreme Court basically saying, look, we live in a world where risks are, many products carry risks, and living in the modern world entails a degree of risks to the exposures that we have. But that should not prevent business from being made. It should not prevent manufacturers from distributing these products to farmers. They should not be made to bear the costly consequences of litigation if people decide to sue because a label was misleading. So fundamentally, I think the incentive behind this ruling is a pro-business one, which is unfortunate because it comes at the detriment of not just consumers, but states' rights, states' abilities to enforce their laws against manufacturers when they fail to warn consumers in those states. It's interesting that the ruling came down from both the liberal and conservative sides of the bench because typically the conservative justices are very sensitive to preserving states' rights and abilities to enforce their own rules and regulations. This ruling kind of undoes that with respect to warning labels for pesticides.
Pedram, such great insight into what the court ruled and the impacts of that. We truly appreciate you joining us today and giving us a peek behind some of the legal curtain in that ruling there. Thank you so much for being with us.
Of course, thank you for having me.